Ladies and gentlemen, there are still many of our colleagues outside collecting their material, and will be coming in, but I think we must get started and allow them to come in during the proceeding. Now, we've got a sellout crowd, so we will need every spare seat that there is. So if you don't mind just kind of shuffling into the middle to leave the outside seats available for the people who will be coming in later, that would be very kind of you. We've got a very full and a very tight program today. The biographic material for each of our speakers is in the book of materials that you have. So with apologies in advance to all our distinguished speakers, what we will be doing is not giving their complete introduction, the introduction they should have. We're going to leave that to be read by you, and we will be simply calling on them to make their presentation. To open our program for these 2 days, I have the honor of calling on our treasurer, Mr. Paul Lamek. Mr. Treasurer.
Thank you, Jim, and I will not keep you from the important work at hand, but on behalf of the Law Society, I am pleased to welcome everybody to the 1993 Special Lectures. As many of you will know, the Law Society has been conducting these Special Lecture series since 1950, and almost always here in Osgoode Hall. They were traditionally the March lecture series, but I have to tell you that I was responsible for a change in that. The hall was under renovation, and so a number of years ago, perhaps 4 or 5 years ago, we switched to a fall program, and it seems to have bubbled around ever since. And in 1991, for the very first time, the lectures were held outside this room, outside Toronto, indeed in Osgoode, in Ottawa. Now, a prime objective of the Law Society's Special Lectures has always been to maintain a standard of educational excellence for the benefit of the practicing bar. And of course, we're seeking to do that again this year. No one can have any doubt about the importance of this year's topic, and indeed the attendance and the enrollment for the Special Lectures bespeaks the wisdom of the choice of topic. Obviously, there are burning issues in the area, particularly at a time when the recent Supreme Court of Canada decision in the case with the unknown pronunciation, is it Moga or Moog or Moge, and the Ontario Court of Appeal's even more recent decision in Elliott and Elliott document the, describes the turbulent state of the law concerning support. And the analysis of how family law has developed and where it's headed will be the concern of the speakers who will address you over the next couple of days. They're matters of concern to all of us, both as lawyers and in our other capacity as members of the public. As practicing lawyers, we often find it difficult to find the time to lift our heads from the files that happen to be sitting on our desks to take a longer view of the development and trend in the law. And this lecture series, of course, provides us with an opportunity to do just that. And it's a very valuable opportunity indeed, given the gravity of the issues with which we're currently dealing and will be dealing in the coming years. It's particularly appropriate that we stop and try to take that long view now, at a time of, frankly, for the Society, mounting concern over errors and omissions claims in this practice area. It's also necessary, of course, to consider our responsibility as professionals in the area, and I'm pleased that in the course of the next 2 days, ethical issues will be expressly addressed. Now, I want to express the thanks of the Society to all those who've been responsible for the development and presentation of the lectures this year, particularly, of course, to Jim McDonald, the Program Chair, and past Director of the Law Society's Legal Education Department, and to the members of his Planning Committee, the Honourable Associate Chief Justice John Morden, Philip Epstein, Winifred Holland, Evlyn McGivney, and Carol Rogerson. The committee members have devoted a very great deal of time, as will become apparent over the course of the next couple of days. A good deal of time, a great deal of energy, and very hard work to the success of this program. In that effort, they've also had the support and backing of the Legal Education Committee of Convocation. And I'd like to express our thanks to all of the other members of the faculty for this program. I'll have the pleasure with the benches of entertaining them at dinner this evening, and I look forward to that and to thanking them in some small and more tangible way for their efforts. But they've had the responsibility of preparing their lectures and also the written material in your program binder. We're, of course, deeply gratified this year's lectures continue our tradition of strong judicial participation in continuing legal education here. And we're particularly pleased, of course, to welcome our two judges from the Supreme Court of Canada, the Honourable Madam Justice Claire Léaud-Dubé and the Honourable Madam Justice Beverley McLachlin. Let me thank also all members of the Legal Education Department staff for their involvement and enormous effort in putting this program together. I know I don't need to express any confidence in the stimulating and interesting time you're going to have over the next 2 days, but I do wish you a very productive, very enjoyable, and very worthwhile special lecture series. Thank you very much. Thank you, Jim.
Thank you, Paul. I now have the pleasure of calling on our first speaker, Mr. Martin Teplitsky, who will talk to us this morning about ethical issues in family law. Martin?
The reviling of lawyers in our society is something that has been going on for centuries, though I'm sure each generation of us thinks that we are more reviled than a prior generation. Certainly the John Grisham series of books, Lawyers About Lawyers, and Scott Turlow's book about, many books about lawyers, hasn't done very much to help the public's confidence in how ethical lawyers are. So I was delighted to have been asked to talk about ethical issues in family law. Probably only Phil Epstein would have had the imagination to think that I might be a suitable person for such a topic. So I give this caveat at the outset to all of you that however saint-like the words, I fully recognize that this is largely a sinner who is speaking to you this morning. But no one is to ask me of the numerous topics that I talk about, or several rather, that deal with money and sex and disobedience of court orders, in which areas I have sinned. So I'm going to talk about, in the short time available, about the Carol Curtis case, which raises two important issues for us as practitioners, one being the subject of disobedience of a court order, and the other being our obligation, if any, to exhort our clients to obey court orders when we know that they're not going to do so. And then I'm going to talk for a few moments about what I consider our fundamental ethical shortcoming, which is in our failure as a profession and as a society to conquer the problems of delay and costs, particularly in the field of family law. It's an endemic problem, but I think very serious in this area, and a couple of suggestions that I have for dealing with that. And then I'm going to move on, if I have time, to deal with sex with clients, which is a controversial topic, particularly in the United States, and has already raised some litigation in Ontario. And finally, I'm going to deal with a couple of points about ethical implications in settlement discussions, particularly as one relates to one's own client. So that's the agenda, and let me get on with it then. Needless to say, a lawyer who disobeys a court order or a client who disobeys a court order will be guilty of contempt, and if we counsel clients to do that, of course, we're also guilty of contempt and guilty of professional misconduct. Before an audience like this, it isn't necessary to elaborate the importance of the rule of law in our society, and any society that departed from the rule of law as governing its affairs and went to self-help would probably be a society that ended up in anarchy. Nevertheless, in family law, I think we are confronted quite frequently with situations where clients seek advice about disobedience of court orders, particularly in the area of access. There is an order for access, and a parent, for whatever reason, doesn't want to turn the child over or return the child in accordance with the order, and they seek our advice and ask us sometimes in advance what they ought to do. The Carroll Curtis case raised that issue somewhat, and I don't intend to discuss its facts because it was a fact-specific issue. My own view is the Discipline Committee did an excellent job. Their reasons are well worth reading by anybody interested in the area. Anyway, the client calls you and says, I don't want to turn the child over. What are we supposed to do when there is a court order instructing them to turn the child over? Well, the first thing that we have to do, if there's time to do it, is approach the court. You have to move the court if you can. Even if you're doing it ex parte or on very short notice to the other side, the safest course, the ethical course, the practical course is to seek an order of the court permitting the departure from strict obedience to the terms of the order. In Toronto today, with all the computerized equipment we have and everyone else in the province has, 100 judges more or less in the general division here, I think there would be very few cases where you couldn't get an appointment with a judge on an emergency basis to deal with that. And if that's possible, that's what you should do. On the other hand, if your advice is sought only hours before the event, or frequently while one parent is standing outside trying to get the child, applying to court is obviously out of the question. And those situations don't ordinarily involve allegations of sexual abuse. More likely, they would involve situations where one parent attends under the influence of alcohol or drugs, or has sent somebody whom you don't know to pick the child up, or the other parent doesn't know. And in those circumstances, not being able to attend at court, your client has the right to refuse access if your client has a bona fide belief that the health of the child would be endangered by complying with the strict terms of the order. And that was the view that the Discipline Committee took in its reasons. It's, in my view, correct, obviously, and there's a considerable authority for that proposition. If the client has a bona fide belief that there is serious risk of injury to the child, they can refuse to turn the child over and not be guilty of contempt. But the other thing that you have to do on their behalf, according to the Discipline Committee, and I think rightly so in most cases, is you must then immediately apply to court to bring the issue before the court so that the court can deal with it. In the Carroll Curtis situation, the subject matter was sexual abuse. The allegation was sexual abuse, and it was obvious that the mother wasn't going to turn the child over at all. So in those cases, it's quite clear that you ought to apply to court. But I don't think it's necessary to do so if it's a periodic access and the intention is not to refuse access on the next occasion, but someone turned up drunk or under the influence of something, and you won't turn it over this time, but you will next time. In those circumstances, it seems to me an expensive waste of time to apply to court. It would be sufficient to write a letter to opposing counsel setting out the reasons why access was denied on this particular occasion, and indicating that access will be honored on the next occasion, assuming the problem doesn't arise again. So I think in the context that the Discipline Committee was speaking of, that application to court is necessary in circumstances, other circumstances where you intend to honor it in the future. I can't see the point of applying to court. One thing that the Discipline Committee emphasized, which would come as a shock to some clients, is that once you take it to court, and the court has ruled on an interim basis, even on a very short hearing with inadequate material and no opportunity to cross-examine or what have you, that's the end of that ballgame. I mean, now your client has to obey. So your client should be advised that you have to go to court. You can't be certain what the outcome may be because of the shortness of time, perhaps inadequate material, as I've said. So they're running a risk, but they will have to obey if the court makes an order or refuses to make an order, and that's it. And that's all I intend to say about the subject of obeying court orders. The other issue, principal issue, that wasn't of a factual nature that arose before the Discipline Committee was the obligation of a lawyer to exhort his client to purge contempt. You'll recall on the facts of that case that the client went underground despite the lawyer's recommendation that she not do so, and during the course of the year or so that she was underground, she contacted her lawyer on a number of occasions to discuss various issues that were bothering her. The solicitor admitted that she didn't attempt to persuade her client to purge her contempt. She did explain to the client that their contempt was hurting her chances of success, and she explained her failure to counsel the client to purge her contempt on the basis that she was attempting to be careful with the client, non-confrontational, and didn't want to lose the client's trust. Moreover, the solicitor was of the view that the client wouldn't come out of hiding in any event if she had to give up the child to the father. In that situation, there wasn't any evidence that the client would have purged her contempt if so advised by her solicitor. Although she sought throughout the proceedings to blame her solicitor for having gone underground, in none of the affidavit material that she filed or in any of her evidence did she say had the solicitor advised her to come out, she would have come out. And of course, on the facts of that case, she never did turn the child over in accordance with the court order. It was only when the solicitor was able to arrange a handing over of the child to Children's Aid that she actually turned the child over. So on those facts, the solicitor's failure to counsel the purging of her contempt could have been excused either because there was no duty in general to exhort clients to obey the law, or because even if such a duty exists, the law does not usually require acts which are known to be useless. The committee, reviewing some limited literature on the subject and having noted that the rules of professional conduct do not require us to exhort our clients to, at least they don't do so expressly, require us to exhort our clients to obey the law, and none of the expert evidence, there was some expert evidence filed before the committee which largely didn't deal with this subject, it dealt with the other subject. None of that expert evidence said that you were under an obligation to exhort your clients to obey. So they found that there was no general duty to exhort your clients. So you don't have to tell them, according to the Discipline Committee, that they ought to obey the law. My view is only slightly different from the view expressed by the Discipline Committee. I say that respectfully. I think, generally speaking, a lawyer should advise a client to obey the law and to purge any contempt. And this has to be correct because ordinarily purging contempt would be in the client's best interests. And we have to advise them, if we're giving them advice at all, to do the things that are right for them to do. And there's also the risk that a client will mistake a failure to give that advice as encouragement of their illegal conduct. Now, I think it suffices if you give the advice. If counseling out of defiance of the law and expression used in the case means that the solicitor must persist in the advice to the point of either persuading the client or losing the brief, I can't see any sense in that. And moreover, I don't see anything wrong as a matter of judgment if you have a client, such as the solicitor faced in this particular case, who had absolutely no intention of ever doing it. I think one could exercise judgment and say, why do it? You're just going to aggravate the person, lose any control over their conduct, and that doesn't make any sense. But I don't think one should take too literally that there's no obligation in any circumstances to be busily advising your client to obey the law. I think we should do that. The last matter that they dealt with that raised some general issue of principle was that the argument was made that a client in contempt must be barred from representation. The Law Society solicitor made that argument. Of course, the committee rejected it. There's no basis for suggesting that a person in contempt isn't entitled to representation and to deal with their contempt. There is, I think, an interesting question that does arise, and that is this. is representation of such a client affected by the fact that you know that they will not obey the law, in the sense that they've told you they won't obey the law? Let us suppose, for example, that a client states unequivocally that he will not turn the child over regardless of how the court rules. Nevertheless, the client wants you to bring a motion. If you win, that's perfect. If you lose, the client won't obey. In these circumstances, however objectionable one may find the client's attitude, it seems to me that the client has the right to seek an order which will bring him within the law. Moreover, if it is the best interests of the child which are at stake, then the fact that the parent intends to disobey is obviously not directly relevant to the issue of whether there is a risk of sexual abuse, for example. For my own part, I would feel uncomfortable acting for a client in those circumstances, but I think it's quite clear that that would not be professional misconduct for us to take a case on for a client who has said that they won't obey if they lose, they just want to win. In any event, a lot of clients are bolder verbally than they are when it comes to take some action. The next topic that I want to talk about is the one that personally interests me the most, and it's one where I think it's of daily application in all our lives as family law practitioners and in general. That deals with this question of excessive delay and excessive cost. The goal of all procedural systems, whether they're adversarial in nature, inquisitorial in nature, some combination of the above, or otherwise described, are to provide a forum within which a fair and just result can be achieved by the disputing parties in a speedy, inexpensive, and efficient manner. A few people would question that the adversary system produces on the whole fair and just results. I'm aware of no literature which indicates that any other system produces better results in that sense. Equally, unfortunately, few would suggest that these results are generated in a speedy, inexpensive, and efficient way. And our most important ethical obligation is to eradicate the problems of expense and delay to the extent we can. And although these problems are endemic to all areas of dispute resolution, it's fair to conclude that their impact in family law is ordinarily more severe than it would be, for example, in commercial litigation. Family law issues touch the ability of people to get on with their lives. They affect the psychological well-being of children and their parents. They require early resolution, which doesn't bankrupt the family or dissipate limited assets. As family litigation drags on, everyone suffers emotionally, even the lawyers, but particularly the children. It seems to me that the loss of the nuclear family is less traumatic for children than the daily sight of their parents at war. In commercial litigation, which ordinarily only involves issues of property or money, pre- and post-judgment interest may prove sufficient recompense for delay. Obviously, it's no recompense at all in family law litigation. Similarly, the costs of commercial litigation tend to be passed on to consumers, shareholders, and to others. Family law clients are probably the last large group of clients who pay their own way and who have no ability to pass the costs on to anybody or to write these off for tax purposes generally. So we have to ask ourselves, why does it take so long to conclude a family law case, and why is it so expensive? Well, I think one significant reason which impacts both cost and delay is the practice of time-based billings, which is now almost universally accepted as appropriate, and I think reflects the practice of most solicitors and law firms. Of course, it wasn't always so that time-based billings were at the heart of practice. When I started to practice, now almost 30 years ago, value billings, or what is now called value billings by the Americans, was the norm. A client was charged what he could afford to pay based on the results achieved, the responsibility undertaken, and to some extent the time spent. Accurate record keeping of hours spent was not prevalent. It was understood that a lawyer could spend as much time as he wanted to, but a client would only pay what the file was worth. I can recall clearly today the advertising that accompanied the call for time-based billings. Maximize your earnings. Attend our seminar and we will teach you how to record your time accurately and how to earn more money. There was little in the movement to time-based billings which was directed to the client's best interests. I note that in the United States, to the extent that litigation isn't dealt with on a contingent fee basis, that the movement is back to time-based, to value billings from time-based billings for some of the reasons which I'm about to give. They have now found they can't live in that. In the world, the public won't accept, the business world won't accept time-based billings as the largest or often sole criterion for determination of fees. With the advent of universal docketing and law firm expectations of a certain number of docketed hours by partners and associates, and advancement within the firm based on meeting these goals, incentives were institutionalized to keep the meter ticking. This phenomenon is also seen in legal aid billings, which are generally based on so much per hour for time spent. Is it any wonder that the length of trials and discoveries have increased dramatically over the past 25 years? 25 years ago, discoveries rarely took more than a half to 1 day for both parties. Today, it's rare that discoveries are completed in less than 3 days or more. Contested capital murder trials used to last a week, and today few jury criminal trials are completed within a week, regardless of the nature of the charges. When one combines time-based billings with rules of practice which offer lawyers a myriad of discretional procedural opportunities, the cost explosion is easily explicable. As files are worked, cases of necessity are delayed. In my opinion, the profession has to return to value billings. The lawyers have to learn to exercise judgment to reduce the time which is spent so that the cost is affordable to the client. With the return of value billings, all discretional procedural opportunities will cease to be for the lawyer's gain at the client's expense. This one change would go some way to reduce both cost and delay. The other thing I think we need to do that the Americans do is get onto a case management system in family law with the trial judge as the case manager. I don't think case management works very well, assuming you can get a hold of some case managers who aren't the trial judge. English experience with limited types of case management with persons other than the trial judge have not been successful. The one loss that people speak to if we have trial judges as case managers is that they won't be able to get involved in settling the case. In my view, trial judges not involving themselves, or the judiciary generally speaking not involving themselves in settling of cases is not a loss to the administration of justice. In fact, it's a gain. I don't think judges should be involved in that for a number of reasons. First of all, there's no evidence, indeed there is an American study to the contrary on pretrial, that universal pretrial is a cost-effective use of judicial resources. Secondly, universal pretrial has removed the incentive for lawyers to settle before the pretrial. Prior thereto, examinations for discovery were seen as the opportune moment to discuss settlement. Today, everybody waits for the pretrial, which exacerbates both the problems of cost and delay. Third, I don't think it's a healthy phenomenon in our society that we're busy blaming pretrial judges for pressuring our clients into settlement, which I think is one of the principal uses of pretrial judges. He made me do it, or he says that's the way it's going to be. I think this brings the administration of justice into some disrepute. And conversely, I don't think it's a healthy phenomenon that we frequently have to criticize a pretrial judge's opinion if it's negative to our client's interest, sometimes fairly, because the pretrial judge's lack of exposure to the file and real opportunity to form a balanced opinion has resulted in the view that we don't share. Of course, cases that turn on credibility don't lend themselves very well to pretrial. Finally, in my opinion, I think it's everybody's experience that the most effective way to get a case settled is get it to the courtroom door. The faster cases get to trial, the faster they're going to settle. Nothing focuses attention as well as the imminent prospect of adjudication. Accordingly, if we utilize judicial resources to assist in getting the cases more quickly to trial and with less expense, we will be promoting settlement in the most effective way and helping to eradicate problems of cost and of delay. As well, lawyers are afraid of judges who are going to try the cases, not in a physical sense, but they respect what they have to say because no one wants to make the trial judge angry. When I arbitrate commercial cases, larger ones, I pre-hear all of them. And we do pleadings on a quick basis. We have discovery and production that is limited to the issues in dispute and isn't at large. And these cases are dealt with much more expeditiously. Trial judges could do exactly the same thing. All lawyers need is a little bit of encouragement not to look under every rock. But in this world of consumer awareness, fear of professional negligence allegations, the meter clicking, everybody wants to look under every rock because more is safer, less work means exercise of judgment, possible risk. A judge, by encouraging the parties to narrow the issues, limit the discovery and the production of documents, can go a long way to getting cases heard with much less expense and much more quickly. In that area, I want to just mention two other points that would help, though they appear later in the settlement portion of my paper, which I won't get to today. Two of the problems about cost and delay in family law are two phenomena that one doesn't always see in other areas as frequently. The first that you see very often is switching lawyers. There's way too much lawyer switching in family law, which adds terribly to client cost and to delay of actions. Now, some of this is because obviously the client loses confidence in the lawyer, but I think that with more effective lawyering, more effective communication with our clients, when people come to me and they tell me I don't like him and I ask why, the reasons are usually very tiny ones. You know, an extra phone call, a little more understanding, somewhat greater sensitivity being expressed to their concerns, I think would stop a lot of this switching around of lawyers, which I think is a serious problem in family law litigation. And it's huge. I mean, I think it's almost impossible to start a family law case and finish it. The other thing that I think lawyers do, which is inappropriate in the family law case, sometimes I notice this, is they barge into stuff and run their clients out of money. You know, there's a big, get a file, a great file, away they go, doing all kinds of junk. The next thing you know, the client's broke. Now, of course, the lawyer's very unhappy, so they get rid of the client. Or they get them broke very close to when the case should be settled. Well, what is a client's prospects when you're sitting there telling them, give me a refresher for the trial or I'm not doing the trial? His options at settlement aren't outstanding. So one of the things that value billings would add, and a little bit of common sense would add to this whole thing, is that you've got to decide on a budget in advance. That's what the Americans are demanding in value billings, a budget in advance, and then I'm not even going to get to sex with clients. I think I did speak longer than I should have on these other topics, probably to avoid having to talk about that. Anyway, I'll just say this with sex with clients. It's the subject that I agonize the most over in my own mind, read the most material on, and in summary it's this. All the literature says that sex with clients ought to be per se professional negligence. No jurisdiction affecting lawyers in North America has been able to pass such a rule despite the literature and despite seminars to that effect. The furthest anyone's gone is California, that reverses the burden of proof. You have sex with a client, you have the burden of showing that the client's interests weren't affected. It seems to me almost inconceivable that if you meet a person and that person becomes your client, you sleep with them, that their interests aren't affected negatively. And you can never be sure about consent in those cases in any meaningful way. In our office, for a long time, we have a per se rule. Sexual harassment of employees, sleeping with clients, you get fired. But I think that's a good rule of common sense. I still haven't made up my mind whether we should, as a profession, pass that as a rule, because there are there's so many exceptions. It isn't, I think, quite the same as the rule with doctors, who, as you all know, under the leadership of Mary Lou McPhedran, the task force passed recommendations on zero tolerance, and those have been adopted by the college. I mean, I don't think the profession would be least bit harmed if we went to zero tolerance, but anyway, I'm sorry I missed out on this opportunity to play, what is her name? Dr. Ruth. Anyway, thank you very much.
Thank you very much, Martin. Teplitsky has alerted us to some of the problems and pitfalls in practice. Now, to completely terrorize us, I will call on Mr. Phil Epstein, who's going to address us on the topic avoiding the negligence claim. Phil?
Well, actually, it's too tall.
Before I begin, and because I'm not sure that there will be another adequate opportunity, I wanted to take a moment to say something about Jim McDonald, who was the chair and who is the chair and the organizer of this program. Jim McDonald is in many respects the father of family law in this province. He was the original head of section of the family law. Of course, he's the founder of the family law section of the Canadian Bar Association. He is widely published. He has affected all of our lives in more ways than we know. He has particularly affected mine, and I wanted to tell you how hard he has worked to put together this program, and I wanted to take a moment to pay tribute to his efforts, not only for this program, but for all of his efforts on behalf of all of us in the family law field over the last 25 years in Ontario. I have nothing more positive to say. However, sex with clients is a topic that does interest me. It doesn't interest my wife, and as a result, I'm going to turn to talk about family law and solicitor's negligence. Now, this is a bit of a harrowing lecture. I tried it out last week in Thunder Bay, and a number of people have been hospitalized since. And there will come times during the course of this lecture that it will occur to you that you might not have followed this advice. And if you have the need to run out and call your office and stop that offer or change that pleading, we'll all understand. We'll all make a note of who's leaving. You are about, unfortunately, to receive notice of a significant increase in your insurance levy. The levy increase comes about as a result of a significant rise in the value of claims and the number of claims that is on an ongoing spiral upwards. The levy has increased fivefold since the inception of mandatory insurance in Ontario, and there may be no end in sight. There is hope, however, on the horizon that perhaps mandatory legal education and other significant efforts in loss prevention will begin to bring down the incidence of claims. But it is clear that all of us have an obligation to each other to practice defensively. Lawyers do not hesitate to sue other lawyers, and clients, particularly in the matrimonial field, do not hesitate to sue their counsel when they are disappointed with the results of their case. If people who lived together and who loved each other for many years could turn against each other and get involved in acrimonious litigation, don't for a minute think that they won't turn on you. And accordingly, it is important that you govern your practices in a way that will reduce the incidence of a claim. All of us, sooner or later, will make a mistake, and some of us will make more than one. But the trick in this business is to design your practice in such a way that you reduce the risk of error. And I want to canvass certain areas of practice. I can't cover all of the ones in my paper, but I do commend it to you because it is a list or a collection of all of the family law negligence claims that have given rise to reports to the insurer during the time that I've been doing this practice, which is now at least about 17 years. So it attempts to tell you what's happening out there and gives you some clues how to avoid it. But I want to pick some particular areas. And in no particular order, I want to begin with offers to settle. Offers to settle are significant traps for the unwary. That is because the case law has now clearly established that if you are in the course of litigation, an offer made to the other side will be construed by the court as a Rule 49 offer. and not as an offer at common law. If you do not have litigation going, then an offer will not be a Rule 49 offer, and the offer will be an offer at common law. And the distinction is important. An offer at common law is revoked by a counteroffer. An offer at common law probably lapses by a fluxion of time. But a Rule 49 offer is a creature of statute or the procedural rules and does not get revoked either by time or a counteroffer. It gets revoked if you withdraw it. And if you don't withdraw it, it stays out there. There are a number of problems, therefore, that arise out of these offers. Firstly, it is incumbent upon you to make an offer at the earliest possible opportunity. The courts have made it clear that they will visit cost consequences on people that have not made offers, and not to make an offer is to invite cost sanctions. You must explain to your client, and you ought to do so in writing, of the client's obligation to make an offer. That doesn't mean you make an offer on day one, and it doesn't mean you make an offer before you get appropriate financial disclosure. But it does mean that you make an offer as soon as it's reasonable to do so. And you must have your client sign the offer. There's no need in any case that the offer may go out so urgently that there isn't time to get the client in to sign it, or at least to sign a facsimile copy. It is important so that the client cannot later argue that the offer was not authorized, and it reduces dramatically the client's argument that he or she misunderstood the offer and didn't know the terms of it. If the offer is going to be rejected, you should have your client sign the rejection and sign an acknowledgement that the client understands the cost consequences of a rejection of offer. We have had a number of cases where clients have leaped over the court railing and tried to strangle the lawyer when it became apparent at the trial that the offer that was rejected was higher than the award and costs were about to be awarded in addition, and the client then says they were never told about the offer. The lawyer says, of course I told the client about the offer, but she rejected it. There's no memo in the file, there's no record of it. It's a simple matter to get the client's signature on the rejection. Marty talked about transferring files in family law cases, and it is true that family law clients change a lot. If you get a file from another lawyer, you have to find out whether there's an offer outstanding. We've had a number of cases where very creative lawyers think of new arguments when they take over the file. The other side sees the new argument, sees the handwriting on the wall, and accepts an offer that was contained in the file before the file was transferred. If you're the lawyer giving up the file, get over your grief and anger about giving up the file and let the new lawyer know whether there are offers outstanding. If the file is voluminous and you're not sure of your position, you may want to consider a blanket withdrawal of all offers until you've had a chance to review the file. But keep in mind, to withdraw an offer may also have consequences. In any event, I don't have time to touch on all of these topics in detail. I just bring to your attention that much more attention must be paid to offers. Pleadings. It is very common for many of you to plead constructive trust regardless of whether you're interested in a constructive trust or not, and I want to talk a minute about that. The matrimonial home at the time of separation is owned by the wife. The husband made all the mortgage payments and frequently paid for the house. He, by knee-jerk reaction, or actually not his knee-jerk reaction of his lawyer, is to immediately claim a constructive trust interest. The home plummets in value. What was a $300,000 home at the beginning of the case is now a $200,000 home at trial, and the husband's lawyer stands up and says, I'm not interested in pursuing the claim for a constructive trust. I would rather have it valued at $300,000 and take $150,000. Be warned that the 3 cases now, judges have refused to allow parties to resile from a claim for constructive trust when the reason for it is that the property has fallen in value. Whether those decisions are right will ultimately be left to a court of appeal because all of them are trial decisions, but you should have considerable thought before you embark upon constructive trust claims when you're not sure you really want a half interest in the property or a half interest in the business. If you ask for it, you may well be stuck with getting it, and it may not be in your interest to pursue that. I want to turn to various clauses in separation agreements that have given rise to serious claims. And the first, of course, and the one that we cannot escape talking about, is pensions. My considered advice about pensions is that try to do a telephone interview of your client when they want to retain you. And if they have a pension, take out a list of people that you don't like and send the client there. Leave it for about 18 months and then call that person up and ask them how they felt about losing their deductible. The pension arrangements in this province are, of course, disastrous because the government passed the provincial legislation without permitting a division of pension credits. That is now being addressed by the Ontario government, but they may not be able to address it in time during the remaining 2 years of their political existence. And if they do not succeed in passing it in the remaining 2 years, it may be quite some time before the legislature in Ontario deals with it. And of course, this is legislation that is badly needed, and you may hear some more about it from Mr. McCamus tomorrow. But until it does, pensions are a serious problem. And it is very difficult to address the problem that if there are only two assets, the house and the pension, and they're both worth the same, the wife gets the house, the husband gets the pension. That somehow doesn't seem fair to anyone. And so as a result, there's a natural inclination, particularly in Ottawa, to try to if and when the pension. As a practical matter, it is almost impossible to if and when a pension successfully. There has been a recent and very gallant attempt to do this in a case called Bordeaux in Ottawa, but it's clear that Jennifer MacKinnon, who's had a very careful hand in the drafting of that judgment, and there's an attempt by the judge to dot every I and cross every T in order to successfully if and when the pension. But one of the features of if and whenning a pension is that there must be insurance. If you don't have sufficient life insurance to fund the if and when arrangements, then there's nothing that you can do practically to prevent the pension from failing. And when it fails, then you're open to a negligence claim. Now, it is possible, I suppose, to tell the client that we're going to if and when the pension, and to tell the client in writing that there's every risk that the pension will fail. I suppose if the client knows that, they can hardly complain about it. But the client will undoubtedly say that they didn't understand the letter and they don't understand why they're still not getting $337 a month for life. The fact is that what happens in most of these pension plans is that the husband, who's usually the pensioner, divorces the wife, remarries, and then dies. And the pension plan will not comply with any order or any agreement, since it's not bound to them, and will not pay the pension benefits to the first wife. Will only pay the pension benefits to the second wife. And unless you have put life insurance in place, you have failed to protect the pension. Now, you can obtain an undertaking that the husband will not die prior to your client. I've never found that particularly enforceable. You can't restrain him from marrying because that's against the public policy. So all you can do is either divide the pension on a lump sum, which obviously isn't practical, or you can if and when it. And if you if and when it and you think you have insurance, think twice, because most insurance that people have in this province is term insurance. And the term insurance either expires at age 65 or 70. Very few people have universal life or level term to 100 because it's very expensive. And with your luck, the husband will die at age 71 and there'll still be no insurance. Now, again, you could require that the husband commit suicide at age 69, but that's, if Dr. Kevorkian has to stay in jail, that won't work either. So there are going to be considerable problems with trying to do this until we have legislation. So do yourself a favor and don't do it. Or more practically, if you're going to do it, make sure that you understand at least all of the safeguards that have to be put into place if an if and when arrangement is going to be carried out. There is considerable case law about this now. but most of the early cases, Porter is the case I suppose we all think about if and when a teacher's pension, Porter will clearly not work. Mrs. Porter is going to be surprised one day when Mr. Porter drops dead, because the court order in Porter is not going to bind the teacher's superannuation fund, and in the absence of insurance, there will be no money. And that brings me to life insurance. It is very common in all of your separation agreements to provide that there be life insurance to fund the support payments. You have to find out or have to agree with your client as to who's going to follow up this clause. If there's supposed to be an irrevocable beneficiary clause, then it's probably the lawyer's obligation to make sure you get the form completed before you close the file. But secondly, you have to take into account whether this is term insurance or whole life insurance. If it's whole life insurance that is being used to fund the premium payments, the support payments, you have to make sure that the husband, payor, cannot borrow against the whole life policy. You can do this by sending an irrevocable direction to the insurer requiring that they not lend on the policy. And you must also check the policy and with the insurer to make sure that the policy has not already been borrowed against, because what may turn out to be a $75,000 policy could be reduced to very little value if there's been full borrowing against the policy. Now, fortunately, we don't see many whole life policies, but we do see a lot of term insurance. And again, since most of these term policies expire at age 65 or 70, and since most people have a life expectancy beyond 70, many of your insurance clauses will not work. Now, it may not matter if there is no other insurance available, then you've done the best you can. But if you have agreed that the insurance replaces the support, and there is no insurance, you have to at least have made sure in your agreement that the husband's estate is going to be bound to make the support arrangements. So make sure that you have covered off both when you do these kinds of agreements. I turn next to pretrials and settlement conferences. I have what I think is a helpful suggestion for you. When you open any matrimonial file, take your master separation agreement that you have in the office, in blank, and stick it in the file. If you stick it in the file, it will operate as a continuing checklist for all of the issues in the case. What happens is that parties go to a pretrial, particularly in Toronto, and there are a lot of subtle and not so subtle pressures that are created for settlement. And pretrial settlement ratios are very high. More than 50% of the cases settle at pretrial. The parties move from room to room. The clients are very emotional. The lawyers are in a hurry to get back to their office. The day wears on. People begin to cry and to scream and to yell. But in the course of all of this, the pretrial judge says, if you let the parties leave, you'll never have a settlement, so draft it now. And we all know from experience that if you let the clients leave, you do sometimes lose the opportunity for settlement. So you go back and forth and you start in handwriting drafting this agreement. The agreement is signed by both parties. You go back to your office, and 3 days later your client calls you and says, I went to pick up my antique war chest from the matrimonial home. My wife won't let me have it. Why is that? And you turn to the minutes of settlement and you see that the clause is that all the contents have been satisfactorily divided and the parties have given each other releases. You also see in your notes in the middle of your 300 letters your client reminding you not to forget about the war chest when this case ends. And the war chest is gone, and now it's a different war chest that will have to be applied to deal with the issue. If you have a checklist in your file and you annotate it from time to time, you will always have it available. If you go to the pretrial without this checklist or without this master separation agreement, you stand an exceedingly high risk of leaving an important issue out of the settlement, such as insurance, such as an estate clause, such as a termination date for a certain event, and so on. So please try to take the checklist with you, keep it available, and refer to it from time to time. Minutes of settlement have the same consequences at trials, and we've had a number of claims from people who were so nervous and so upset at the trial that suddenly settled in the middle that they have very little recollection of what instructions they gave and very little recollection of what was done. We who are used to being in trials and being in that kind of confrontational atmosphere are used to it, but clients are not, and they sometimes forget about things that were important to them, even though that your file is replete with references of what was important to them earlier. So take these minutes of settlement or these draft contracts with you and keep them in mind when you're discussing minutes of settlement. Interim agreements that are always entered into by parties who are seeking tax relief seem to be an area of difficulty. What frequently occurs is that the agreements are not drafted in a way that call for the tax relief that was intended. Entering into agreements where the husband will pay the wife $3,000 a month and pay the wife's tax are not a good idea. They are create serious misunderstandings. Is it intended that the wife's tax be an additional deductible amount for the husband? Because if you think it is, let me tell you that it isn't. And you're far better off to gross up the amount that the wife needs and then get the full tax deduction. But what lawyers do is they then decide that there'll be third-party payments, and there is confusion in terms of how these third-party payments are dealt with. Sometimes people don't make reference to the particular statutes that are needed in order to make sure that the interim agreements comply with the requirements of the Income Tax Act. It's beyond the scope of this discussion to go over the wording of each of the agreements, but simply to tell you that the Bar Admission Course precedents, O'Brien's, a number of other groups have detailed precedents for these interim agreements. And you should not be sitting at your desk drafting an agreement with a dictaphone. You should be looking at a precedent and making adjustments to the precedent and precedents that have been tried and tested so that you can ensure that the tax consequences that you wish to occur will in fact occur. Marriage contracts. Jerry Sidveri will talk later in the program about setting aside agreements, but certainly cohabitation and marriage contracts are an area of very considerable litigation. It should go without saying, and for that reason I won't repeat today, that you cannot, under any circumstances whatsoever, on any day, any place, at any time, act for both parties to a cohabitation agreement or marriage contract. It is surprising, however, how often that occurs. In one recent case, the lawyer is found to have said to both parties, you shouldn't go to other lawyers because they will just get you fighting, and if you stay with me, I will help you reach an agreement quickly and effectively, and it will organize and help you settle your marital affairs. We know the lawyer said that because both clients have on discovery subsequently repeated that conversation, and it's simply too good not to be true. These parties are in an adversary position. Now, it is the case that sometimes clients you have known for some considerable time will want to come into the office and talk about a cohabitation agreement, and you will have seen them both. That doesn't mean, I think, that you can't continue to act, but you must immediately, after you've begun to explain the outlines of what you propose to do, send one client away and make sure that that client retains a lawyer. Do not give that client a name of one lawyer, and do not send that client down the hall. If you do, it will be subsequently argued that there was no real independent legal advice, the client had no choice of counsel, and this was a rigged agreement. You are far better off in these cohabitation and marriage contract situations to give the client a list of lawyers and let the client choose one of the lawyers and then begin negotiations. And you are far better off in these marriage contract and cohabitation agreements in not giving the other side an agreement to take to the other lawyer. Because what typically happens is the client who is unrepresented takes the agreement to the new lawyer. The new lawyer looks at the agreement for 15 minutes, the party signs the agreement, and then we have a lawsuit. And what happens is the second lawyer who gave the independent legal advice is sued because he or she did not investigate the financial circumstances of the parties, did not investigate their own personal and emotional circumstances, and did not satisfy himself or herself that it was a fair and reasonable contract. So that lawyer is easily drawn into the litigation. But the husband who got the benefit of the agreement now gets worried when the agreement is under attack that his lawyer didn't tell him the best way to go about getting a contract, so he adds his lawyer to the litigation. So now we have two lawyers and two parties in the same litigation. It doesn't matter that we will be successful, or we may be successful in defending you. The fact is we're successful in defending 75% of all of the claims. But we spent $16 million last year in successful defenses. And $16 million is too much money to spend on successfully defending claims that could have been avoided by the exercise of common sense and good judgment. So when you have these clients in your office, send one away, then start negotiating by letter, and once the letters reach a formative point where you can draft an agreement, then send the draft agreement. The other thing that happens when you give clients a contract to take away is sometimes the other side decides they won't get independent legal advice at all, and they just sign the agreement. Then they later attack it on the grounds of independent legal advice, and you're asked why you didn't take the necessary steps to make sure the other side was properly represented. Now, all of this, you may say, is grossly unfair to the lawyer, and that may be, but if you practice defensively, this situation would not have arisen in the first place. And that brings me to one of the most bizarre of all of these claims, and that is independent legal advice. All of us are asked at some time or another to render independent legal advice. And as I've said before, and I'm always fond of repeating, if you charge $100 for independent legal advice and you pay your deductible of $6,000, you can't make it up in volume. So independent legal advice causes a considerable drain on the Law Society insurers' resources. And it does so because lawyers fail to follow certain fundamental steps. Now, I don't say this from the tower of a Bay Street office and that I do not understand what goes on around the province and the need to give parties independent legal advice. Because I've represented lawyers from all corners of the province, I think I do have a good understanding of the realities of practice. But nevertheless, if you want to give independent legal advice in a cursory fashion and you want to charge the $100 to do so, you are inviting serious trouble and a serious risk of your deductible. If you are going to give independent legal advice, there are certain things that you ought to keep in mind. And first of all, they must be independent. To be independent means you treat the matter as though you were entirely independent and make all of the inquiries that you would normally make if you were retained as an independent lawyer. Second of all, you're supposed to give legal advice. You're not supposed to say, Mrs. Jones, do you understand the agreement? Fine, sign here. In the vast majority of the claims that we have defended for lawyers and independent legal advice, the lawyer can't honestly remember the meeting with the client. We've had situations where on discovery they didn't recognize each other. Now, that may not be surprising if you've seen thousands of people, but although the client won't remember the face of the lawyer that gave the independent legal advice, they will remember exactly to the word what was said. And they will remember that it was a 5-minute interview. You will remember that it's a 40-minute interview. And you will have no notes in your file. You will have no correspondence with the other side. You will have no investigation of the financial circumstances of the other side. You will have likely not sent a bill, or if you've sent a bill, it doesn't reflect the time you spent. Most importantly, you've not sent a reporting letter. I don't think I've defended a single lawyer on an ILA case where there was ever a reporting letter. So let me try to tell you some of the things I think you must do if you're being asked to give independent legal advice. Firstly, open a file. Most of the time when we're asked to defend, there was no file. We can't find a file. In one case, the lawyer charged $10, pocketed the $10. It doesn't even appear in the trust ledger or in the general ledger. That was a very expensive $10. It cost us $110,000. Open a file. Write down the client's name, address. Ascertain whether the client in fact speaks English. If the client does not speak English, do not allow the person who has an interest in the agreement to be the interpreter. If the client needs an interpreter, go out and hire an interpreter or make sure the interpreter is reasonably reliable. If possible, have a student or somebody as a witness. For no other reason, you should hire an articling student just so that they can be around to witness all the ILAs. It will solve the complete articling shortage in the province. If possible, in fact, have a witness. Take the time. You can't do independent legal advice in 5 minutes. Make the inquiries. If this is ILA about a cohabitation or agreement or a separation agreement, you must have financial disclosure. You can't waive it. So you've got to ask for a financial statement. You've got to inquire about conduct. In one case, the lawyer was asked for ILA. The wife started to tell him about how much the husband was beating her. He said he didn't want to hear about the battering. He just wanted to hear whether she agreed with the contract. He now admits that the client told him about the battering, but he didn't think it was relevant to the ILA. We're in the process of battering that lawyer. Thank you. So you must know about the conduct. Now, of course, if you do all of these things, it's obviously apparent that you can't do it for $100. And if the client doesn't want to pay for the appropriate independent legal advice, don't give the appropriate independent legal advice. It won't be appropriate, it won't be any use, and it will be an invitation to a lawsuit down the road. And for every premium dollar collected, there will be thousands more at risk. So independent legal advice is often needed. It's needed by banks, it's needed by trust companies, it's needed by other parties to agreement. But there are simple elements that must be fulfilled. And lastly, but not leastly, with respect to independent legal advice, you must send a reporting letter. If you send a detailed reporting letter, even if you don't remember the client, you'll at least remember, and the letter will set out what you did. You'll confirm that you met. You'll confirm that for how long you met. You'll confirm why you dealt with particularly unusual clauses. You'll confirm the risk. Like Mrs. Jones, you understand if you sign this guarantee and your husband goes under, you'll lose your home. And you'll confirm that to the client, and you'll dramatically reduce the possibility of being exposed to a claim. Let me finally deal with registered retirement savings plans. Many of you, in the course of a settlement, roll over retirement savings plans. You must explain in writing to your client the consequence of taking an RSP rollover. You don't want the client to come back later on and say she thought she was getting $73,000 in cash and she thought the RSPs were cash. It doesn't matter that you explain it in your office. Explain it in your reporting letter, the consequences of collapsing the RSP. Make sure you see the securities that are being rolled so that you know and can ascertain that they're marketable securities and that they have the value as represented. Make sure when I say they're marketable that they can be freely traded and freely converted if your client wants to deal with them. And finally, make sure that the RSP plan being rolled is not a locked-in plan. There have been a number of cases where the plan attempting to be rolled was locked. And on the surface, you couldn't tell that it was locked. The consequences of a locked plan is that it can be only used upon retirement for a registered investment fund, and that means if your client ever needed the money for a rainy day, it can't be cashed. So make sure you specify what the securities are and the type of plan so that you don't get caught with a client having surprises. There are a host of other areas, probably 50 or 60 mentioned in the paper, that are attempt to tell you areas where other people have gone wrong. And I hope if you have a chance to glance at it, it will lead you into a direction where your chances of making an error are considerably lessened. Thank you for your attention.
Phil, thank you very much. You've enlightened us a great deal, even though you've made all of us feel slightly more nervous. And I'd also like to thank you for your excessive personal remarks at the beginning of your talk. We're now very pleased to hear about a case that we all know of in some way. It's been probably the most influential case in family law emanating from the Supreme Court of Canada in a good many years. And to fill us in on what this case means to us and its implications, I'm pleased indeed to call upon Professor Carol Rogerson to talk to us about support after Moog.
Good morning. I've been assigned the somewhat daunting task of trying to assess the legal landscape of spousal support after the Supreme Court of Canada's decision in Moog and Moog released last December. I should say that my paper, which is still in progress, will treat the issue in much more detail than I'm going to be able to do this morning. There's absolutely no doubt, as Jim said, that Moog is a landmark decision, one that has transformed the legal landscape of spousal support, just as the Pellick decision did 5 years earlier. In Moog, the Supreme Court of Canada reviewed the developments in the area of spousal support over the course of the past decade and clearly rejected the trend towards minimalist spousal support that had developed as the dominant pattern. One of the clearest rulings in Moog, and as I will go on to discuss, I don't actually think all of the rulings in Moog are that clear. But one of the clearest rulings in Moog is that judges had been distorting the divorce legislation by placing an undue emphasis on values of spousal self-sufficiency and a clean break, thereby ignoring the other legislative objectives for spousal support. The Pellick trilogy and its notorious causal connection test, which had really come to symbolize this trend towards minimalist spousal support awards, was clearly rejected as a source of general principles for spousal support and instead relegated simply to apply in cases where parties had settled their spousal support obligations by contract. There's no doubt that as a result of the ruling in Moog, the trend towards minimalist spousal support awards has been reversed. There's been a very noticeable shift in the law. I actually tried to review the past 10 months of judicial decisions on spousal support, attempting to apply the principles laid down in Moog, and my paper will review those cases in a fair amount of detail. What that review showed to me, or revealed to me, was by and large a pattern of much more generous spousal support awards than in the past. Awards in general for much longer periods of time and for much higher amounts. I would say that as a result of Moog, spousal support has been revived as a serious legal obligation. I mean, people used to tell me, as I was writing on spousal support, I mean, forget it, spousal support is a legal anachronism. I mean, why don't you spend your time writing about something that's more real? I think as a result of Moog, spousal support now is a real, serious legal obligation. So I think the general impact of Moog is very clear. The more difficult issue, to my mind, is trying to figure out what basic principles underlie this dramatic shift in the law. What are the new rules for spousal support that we are left with after Moog, beyond the general direction of more and for longer? As I'm sure you're all aware, and I made it actually one of my missions in speaking about spousal support to make people aware of this, prior to Moog, there was a lot of confusion and debate about what the appropriate principles for spousal support would be. I think a lot of people were very united in their criticism of the pattern of minimalist awards that had developed prior to Moog, but they actually disagreed about what the appropriate solution was. I mean, they disagreed about the recipe for reform. One group of critics had as its primary concern, its primary focus, post-divorce poverty and the economic dislocation caused by divorce. The recipe for reform of this group of critics was that spousal support should have as its main goal maintaining adequate standards of living after divorce. This group of critics basically said spousal support should focus on meeting post-divorce needs, forget about trying to assess the origin of needs, take them as they exist at the end of the marriage, and meet them. Another group of critics, drawing on a fairly extensive body of academic literature, both in Canada and the United States, saw the problem of spousal support differently. And they said the problem of spousal support is its failure to compensate women for the economic consequences of the division of labor in marriage. And in particular, the problem with spousal support is its failure to compensate women for the economic impact of their child-rearing responsibilities on their income-earning capacity. The recipe for reform of this group of critics was not to revive what might be thought of as more traditional notions of support based on a response to post-divorce need, but rather to conceive of a kind of new role for support, a compensatory role. And on this understanding, spousal support would actually start to act more as an adjunct to schemes of property division. And it would have as its main goal sharing gains and losses in income earning capacity, which were the result of the marriage. Now, just to summarize and to put it fairly simplistically, I think prior to Moog, there were two competing conceptions of what the primary focus of spousal support should be: need and a post-divorce standard of living on the one hand, and compensation on the other. And I think you can see in the title that Jim chose for my talk, he's trying to play off those two concepts of compensation and need. Now, I think in many cases, and I'll call them the typical cases, it probably doesn't matter very much which philosophy you choose. Women are poor after divorce, and they're poor, or at least poorer than their husbands, because they spent their time raising kids rather than developing their income earning capacity. And so an award of spousal support, which responds to their post-divorce needs, is also going to serve to compensate them for their child rearing. So in the typical case, it probably doesn't make too much difference, and this debate about philosophy is something that interests only academics. But I think there are cases where the two philosophies don't converge, and where it will make a difference, which you emphasize. And I think we all know which cases those are, and the classic case is the case of the ill or disabled spouse. Now, people had hoped that Moog would resolve some of these debates about the basic principles of spousal support. And on first glance, the decision does appear to do that. Unlike Madam Justice McLachlin, who in her concurring judgment said the Divorce Act contains 4 objectives, they're based on very different philosophies of spousal support, the legislature hasn't sorted it out, and it's certainly not up to judges to sort it out. Justice LaRue-Dubé took a different approach, and she did attempt to articulate an overarching philosophy of spousal support to try to reconcile the diverse objectives in the Act and provide some basic guide to their interpretation. She took it upon herself to try to make the Divorce Act coherent and to read some sort of coherent philosophy into it. Drawing on the extensive academic literature on spousal support, and if you've read the judgment, you know, I mean, it's heavily, shall we say, footnoted to the academic literature, Justice LaRue-Dubé comes down on the side of a compensatory philosophy of spousal support. She tells us in the judgment about the characteristics of a compensatory philosophy, and they're all characteristics that are familiar to anyone who's read the literature on the compensatory idea of spousal support. She tells us that spousal support doesn't flow from the fact of marriage itself, but from what went on during the marriage. She tells us that the focus of the inquiry in spousal support cases should be on the effect of the marriage in either impairing or improving each party's economic prospects. She also tells us that we should really think of property and support as being linked. We shouldn't think of them as rigid categories, and we should see them as being linked by a common set of principles, and that common principle is to distribute equitably between the spouses the economic consequences of the marriage, its advantages and disadvantages, its economic benefits and its economic burdens. While acknowledging the potentially wide range of economic consequences which can flow from the marriage and which would require compensation, Justice LaRue-Dubé emphasizes that the most common and compelling claims for compensation, given current social arrangements, will be in response to women's sacrifice of their own employment opportunities due to the assumption of family responsibilities, in particular child care, while their husbands have been able to pursue their economic goals unimpeded. One of the clear messages to come out of Moog, and this message is very much emphasized in Peter and Beblo, a decision many of you may also have read, a decision dealing with the issue of constructive trust claims between unmarried cohabitants, released a couple of months after Moog. In Peter and Beblo, the court tells us in a way what they thought they said in Moog, and they said in Peter and Beblo that Moog, the message of Moog is that women's unpaid work in the home has economic value. It carries significant economic consequences in terms of foregone opportunities, and women's unpaid work in the home requires compensation. So, back to the debate about basic principles, Moog seems to say that the basic principle is a compensatory principle. The focus of the inquiry in making support awards should be the economic impact of the marriage on the spouses. Its basic purpose should be to share equitably the economic advantages and disadvantages of the marriage. And the main function of spousal support is going to be compensating women for their unpaid work in the home, particularly child rearing. The big question we are left with after Moog is, what are the implications of this choice of governing philosophy? What has become apparent to me is that although the Supreme Court of Canada tried very hard to clarify the rules and spent many pages doing it, there are still many unanswered questions to be worked out after Moog, worked out through exercises of judicial discretion at the lower court level. And I think there's still actually a fair amount of continuing confusion Perhaps not so much in the large body of typical cases which involve interruption of work due to child-rearing responsibilities, but certainly in the harder cases, I think there's still a lot of continuing confusion. To some degree, continuing uncertainty in this area was probably inevitable. I think you can argue that, I mean, in some ways, the Supreme Court of Canada did about as much as one could expect. These are very difficult issues. The Supreme Court of Canada tried to lay down some general rules, knowing that the specifics would have to be worked out over time in response to concrete fact situations. While I think that there's some truth to this, on the other hand, I think that part of the problem resides in the judgment itself. Despite many remarkable and truly admirable aspects of the judgment, I think a careful and honest reading shows that there's certain inconsistencies and ambiguities within the judgment itself that contribute to some of the continuing confusion. What I would like to do now is to briefly review some of these unanswered questions and give you some indication of how lower courts have actually been dealing with them. Whether lower courts are right or wrong is another issue, but I thought it might be useful to have a kind of overview of how things are developing. The first issue I'd like to deal with is, what does Moog's emphasis on a compensatory philosophy of spousal support mean in the hard cases? And by the hard cases, I mean cases where there's going to be significant economic dislocation at the end of the marriage. There will be a significant drop in standard of living experienced by one spouse who has limited or no earning capacity. Perhaps there will be fairly extreme need on the part of that spouse. But the marriage itself did not involve at all, or to any large degree, economic sacrifice on the part of one spouse due to the assumption of family responsibilities, or any contribution to the other spouse's improved economic position. There are a variety of fact situations that give rise to these, what I'm calling hard cases. And I think you can all list them in your own minds as I raise the issue. Cases of illness or disability, particularly outside the context of a long traditional marriage. Illness arising in cases of short marriages, second marriages, and then claims by disabled husbands who once were the primary earners and who are now making claims against their wives who were secondary earners during the course of the marriage. Another situation in which these hard cases come up is second marriages, where parties actually come into the second marriage with earning capacity that's already been limited by events in their prior lives, by illness, by age, by assumption of child-rearing responsibilities in a first relationship. And in some of these cases, people come into the marriage and are on social assistance at the point of the marriage. The other hard cases involve childless couples where both spouses have been fairly free to pursue their economic goals unimpeded by the marriage, but one spouse just earns a lot more than another, a doctor, a nurse, a lawyer, and a legal secretary. Or we might have a case where one spouse, who is, for example, an artist, has earned no income during the marriage and has, in fact, been supported by the other spouse. And on a compensatory view of things, you might say that this spouse has actually been advantaged by the marriage and has been allowed to pursue his or her interests by being supported by the other spouse. Now, in these hard cases, more traditional concepts of support based on concepts of need and maintaining post-divorce standards of living might suggest that support should be awarded in these cases because there's going to be a drop of standard of living, there's going to be economic dislocation, there's going to be need. And I think one of the questions after Moog is, does Moog's emphasis on the compensatory nature of support mean that there will be some post-divorce needs that spousal support won't meet? Is the compensatory principle put forward in Moog really, in the end, simply a softer version of the causal connection test? One which undoubtedly takes a more generous view of what economic consequences flow from the marriage than when courts were applying it following Pellick. But in the end, is the compensatory principle a principle which requires that we make distinctions between different kinds of relationships and their economic consequences, and that we reach the conclusion in some cases that these economic consequences really just don't flow from what went on during the marriage? And if that is the implication of the compensatory principle, is compensation the only basis for support after Moog, or can need, apart from compensation, still be a basis? Now, you all wish that I had the answers to this, right? The answers to these questions are very difficult. There are points in Justice Leroux-Dubé's decision when she seems to suggest that compensation is the exclusive principle that underlies all support. And you can infer from that, well, if compensation is the only principle, and that principle actually has some bite, it's going to mean that certain needs won't be redressed after marriage breakdown. However, at other points in the judgment, Justice Leroux-Dubé actually recognizes, when referring specifically to the objective in the Act about meeting, recognizing economic hardship which results from the breakdown of the marriage. She recognizes at that point in her judgment that compensation is not the exclusive objective of spousal support, and that there will be cases where spousal support can be used to meet needs even when they aren't related to the marital division of responsibilities. And she explicitly indicates that support may be awarded in the case of an ill or disabled spouse. The problem with the judgment is that there is actually no discussion in it of the justification for imposing this sort of obligation, and we're given very little guidance on how much weight to give to these, what I'm calling non-compensatory objectives, based on the idea of relieving economic hardship unrelated to the marital division of labor. Does one imagine that these objectives could give rise to permanent obligations if the need is permanent, or would these obligations be more of a transitional nature to allow some adjustment period? Would we imagine these obligations with respect to economic hardship being assessed against the marital standard of living, or do we imagine economic hardship to be assessed against some sort of standard of basic necessities? Rather than giving any guidance on how to handle these non-compensatory objectives, I think that the judgment actually further confuses the issue by drawing these non-compensatory objectives into the general principle of compensation. If you read the judgment carefully, and it actually took me a couple of times of reading it to catch all of the details, if you read the judgment carefully, you will see that at some points, but not all, the principle of compensation is framed as a principle of compensation for two things. It's compensation not just for the economic consequences of the marriage, but it's also compensation for the economic consequences of the marriage breakdown. This expanded reformulation of the compensatory principle merges what I think are two very different understandings of compensation. Compensation for the economic consequences of the marriage is what the academic literature means when it talks about a compensatory philosophy of spousal support. And it is indeed true that many of those consequences of the marriage are revealed at the point of marriage breakdown. But it remains true that the consequences flow from what happened during the marriage. Compensation for the consequences of the marriage breakdown, understood as some sort of independent principle, could mean compensation for the drop in standard of living as a result of the marriage being over. This, to my mind, is a very different concept of compensation and is perhaps not even appropriately labeled compensation. I think it's rooted in a very different understanding of support, which sees support as protecting against the economic dislocation of divorce. On this interpretation of the compensatory principle, you could end up with a very expanded principle of spousal support, especially when it's put together with some loose comments in the judgment that the purpose of support should be to put the remainder of the family in as close a position as possible to that of the household before divorce. Now, I think, just a footnote here, there are a lot of inconsistent statements in the judgment about the role to be played by a custom standard of living. At some points in the judgment, Justice Leroux-Dubé emphasizes that spousal support will not guarantee the accustomed standard of living across the board, that you really have to assess compensation on a case-by-case basis. But perhaps in long marriages where the parties' lives have been so intertwined for so long, and you can't really separate out the advantages and disadvantages, the marital standard of living would be appropriate. But there are other places in the judgment where the principle isn't so qualified, and there are kind of these loose references to keeping the remainder of the family in the same position as before divorce. If you put those comments together with this expanded principle of compensation, you could end up with a blanket principle of, in every case under the sun, spousal support should guarantee the accustomed standard of living after marriage breakdown. What I see from my reading of the case law is that courts are really struggling in these hard cases with how to interpret the compensatory philosophy, and in particular with how to deal with this last part of the compensatory principle, dealing with the economic consequences of the marriage breakdown when those consequences can't be traced to the marital division of responsibilities. And although I think a lot of the case law after Moog is very straightforward, it's here that I see a real split. One strand of the case law, and it's actually the strand of the case law which I think interprets Moog and the compensatory principle properly, takes the approach that compensation for the economic advantages and disadvantages flowing from the marital arrangements, particularly child rearing, is the primary focus of spousal support. And judges who fall into this stream understand Moog as requiring them to do a careful case-by-case analysis of the economic arrangements within the marriage and trying to assess what flows from those arrangements and what doesn't. These cases recognize that some of these non-compensatory factors, such as need and economic dislocation alone, can be a basis for support, but that they definitely play a secondary role. To put it another way, the lack of connection between post-divorce need and marital arrangements may not affect entitlement. There may be some support to be awarded, but it does affect quantum and duration. And the result in these cases is often limited awards, limited in duration and limited in quantum, to deal with cases of the ill or unemployed or unemployable spouse when that situation isn't a result of the marital division of labor. And I think what this approach does is to really put a lot of meat, in a way, into the compensatory principle. And I think in the end, the decision gives out a lot of confused messages. What I see in these hard cases is very much a continued interplay and tension between the two fundamental concepts of need and compensation that I laid out at the beginning. And I don't think that tension has actually been resolved by Moog, and that we're going to see a lot more litigation in these, as I call them, hard cases of illness, disability, and second marriages, where the principles actually do make a big difference. In my 5 minutes remaining, I'd like to talk very briefly about the second set of unanswered questions that arise out of Moog. The second set of questions goes as follows. Assuming a compensatory framework, forgetting for a moment all these issues of non-compensatory objectives, how should courts go about quantifying the amount of compensation that is appropriate? How should courts go about attaching a dollar value to the economic advantages and disadvantages of the marriage? And let's assume a typical case, the case that's going to generate most of the claims, a case where the wife has given primary attention to child rearing and hasn't pursued her career. How do we actually go about quantifying the compensation that's due in those cases? Moog says almost nothing about this, because in Moog the issue of quantum was not actually appealed. And if you read the end result in Moog, Mrs. Moog actually ended up with a very limited amount of support. Now, her husband was poor, and there weren't a lot of resources there, but she ended up with $150 a month. So Moog doesn't give us a lot of guidance. I think what some people imagined the day after Moog was decided was that spousal support was actually going to be dramatically changed, that spousal support litigation was going to turn into something like tort litigation, that everyone was going to be leading economic evidence on the gains and losses in income earning capacity, that awards were almost always going to be lump sum property type awards, and that spousal support would no longer involve looking at the future post-divorce at all, that Moog said you have to look at the past. And people thought, well, there's not going to be any more discussion of standard of living, of need, of means. That's all out the window. It is true that some of the academic literature, imagining new schemes of spousal support rooted in these compensatory principles, does contemplate schemes like this, schemes that look very little like spousal support as we now know it. However, what I would have to say, based on my reading of the post-Moog case law, is that those predictions have not proven correct. On the issue of economic evidence, an issue on which I think the Supreme Court of Canada was somewhat ambivalent in Moog, I think the case law to date has shown that that evidence is certainly not required, and in the Court of Appeal in Elliott, I think the message is that the court refused to allow that economic evidence to play any central role in quantifying support. I think the economic evidence exists as a backdrop to the general philosophy in Moog and its support for the conclusion that child rearing has significant economic consequences, but I don't see it starting to play a very large role in day-to-day litigation. On the issue of lump sum versus periodic, I think we've seen a continued preference outside of a very narrow range of unusual cases to redress economic disadvantage flowing from the marriage through an award of periodic support rather than lump sum. And I think, again, Elliott kind of confirms this. And despite all of the language of economic loss and impaired earning capacity on the part of the wife, in the end, after the courts have reviewed the marital history, reached a conclusion, she raised children, she's been disadvantaged. At the point of quantification, the focus shifts to post-divorce economic circumstances. The husband's earnings, the wife's standard of living after her divorce, and her future economic prospects. All fairly familiar territory to family law lawyers. Now, I don't think this is to say that Moog hasn't made a difference. It has. Courts are willing now to assume fairly significant economic disadvantage flowing from child rearing. They're making more awards for permanent support and for indefinite periods of time. The awards are higher. I don't think they're equalizing income, but they're certainly more generous than they were in the past. And I would say that Mrs. Elliott actually got a very generous support package, more than she would have gotten a few years ago. But in the end, while in some ways Moog has made an enormous difference in support law, in other ways it hasn't been the complete revolution that some people expected the day after Moog was decided. I think that these issues of need and post-divorce standard of living that have been the traditional fare of spousal support have not disappeared, and that they're still at play, and there's a lot of interplay between these concepts of compensation and a lot of the older concepts that you as family law lawyers are very familiar with. Thank you.
Carol, thank you very much. Now, as all of us realize, we are holding this program on a very significant day, and to help commemorate that day, I have the honor of calling upon Brendan O'Brien, a former treasurer of the Law Society and a long-standing colleague. Mr. O'Brien.
I suppose that most of you know that the original November the 11th that we commemorate today was November the 11th, 1918. And since there are very few of us left who remember that day, I suppose that's one reason why I was chosen for today's words. Now, over the course of time, November the 11th has come to have a broader meaning. We now relate it to World War II, even though it was not a significant date in that war. The Law Society has held ceremonies in each year to remember November the 11th. And this year, the Law Society ceremony will be held about an hour from now in the Great Library, where we have the War Memorial for World War I. And it's therefore appropriate for us to reflect on the meaning to the profession of the losses that were suffered in World War I. It's especially appropriate to think back to World War I because of the truly shocking losses that were suffered between 1914 and 18. The extent of these losses can be better appreciated when I explain to you that in 1914, the total number of lawyers in Ontario was between 1,500 and 2,000. The precise number I find hard to get, especially since the honor roll includes students who were lost overseas. But if we assume that about half of these would be considered too old for military service, we are left with 800 or 900 plus students. And of this number, 113 did not come back, which means 1 in 9 or 10 who enlisted paid the supreme sacrifice. And few of the others escaped without battle injuries. Those who were lost were, of course, the youngest and most promising members of the bar. And a review of the names on the list reveals that in many cases there were more than one in a family were taken. There are 8 instances where the same name appears twice in the honor roll. This is in the, the memorial upstairs in the Great Library. Dreadful as were the losses in World War II, we can take some small comfort in the fact that not only were fewer lives lost, 50 against 113 in the First War, but the 50 who were lost represented a much smaller percentage of those in the bar at that time and those who enlisted, because by 1939 there were about 3,200 lawyers in Ontario. I don't want to minimize or rationalize the dreadful losses that were suffered in World War II by making statistical comparisons. But in this room today, it's quite impossible to fully grasp the horrors of 1914 to 18. And few of us today remember these years. When the war started in 1914, I was 5 years of age and 9 when it ended. And it was during these years that I began to read the newspapers every day. And it seemed to me then that the horrors of war were the norm, and that peace was something that was remote and improbable. I can still remember that the long casualty lists that appeared every day in the papers, and the worried looks of my parents and school teachers and other grown-ups in the darkest days of the war in the spring of 1918, when it was feared that all the losses and suffering would be for naught, and that the Allied lines in France would be overwhelmed, and that the war would be lost. But it seemed only a very short time until November the 11th arrived, and in fact, perhaps it's not well known that there was a false armistice on November the 9th, which was a Saturday, and the final official armistice came on November the 11th, which was a Monday. The fact that we honor this occasion at 11 o'clock, of course, is a fiction, because the actual end of the war came 11 a.m., November the 11th, local time. And if it was 6 hours, as I believe it was, that would mean about 5 a.m. this morning that the war actually came to an end. Now, we could hardly believe it was all over, or at least so it seemed. But as we now know, it really wasn't all over. Not only were the families that would never be the same after by reason of the loss of loved ones, but there were the crippled and the maimed that we could see everywhere on the streets around. And in a few short years, 1939, World War II was upon us. So today, let us try to remember those who did not come back from these wars and to thank them for what we have today. Because of those who fought our battles, let us honor their memory for a brief time. Thank you.
Mr. Bryan, thank you. We will now have a coffee break, and could we please try to be back here in 15 minutes, if that's not asking the impossible, but you can bring your coffee with you if you haven't finished it in that time. Thank you.